looks like we are live. What is going on, Bree Hive? How is everyone's Tuesday going today? Welcome back to the live stream. For those of you who do not know me, I am Boss Attorney Bree, and here on this channel, we cover celebrity lawsuits, trademark lawsuits we feel like covering, and today we have a little bit of whatever the heck, and we also have a trademark lawsuit that is going to the Supreme Court. I think we touched on that Supreme Court case a little bit before, but I can't quite remember, and I didn't have time to go back and look. So we're going to get into the facts of that case, and then we're also going to get into the requested case involving Velveeta macaroni and cheese, because last Thursday we had a good stream talking about, what did we talk about last Thursday? The boneless chicken wings, or what do they call it? Boneless wings from Buffalo Wild Wings, and someone sued a class action, felt like they were wrong and misled about it not actually being wings that is deboned. And so today, the chat requested that we cover the Velveeta cheese, where a lady complains that it's misleading because it's not done in 3 minutes like the packaging says. So we're going to take a look into that. We're also going to take a look into the Supreme Court case that I was just talking about. That's actually going to be heard on Wednesday. So hopefully we'll have a result coming from them soon. I don't know exactly how long it takes for the Supreme Court to get back to us, but hopefully it's not too long. If you guys are watching on the live or you're watching on the replay, please be sure to hit the like button, hit subscribe if you're not already subscribed, to help us out in the algorithm so we can get more friends. We are on the road to 50,000 subscribers for the end of the year. So if you are not subscribed and you want to help us reach that goal, go ahead and hit the subscribe button. All right. Y'all, I just ate some spicy food and my ears are like a little plugged right now. So I feel like I can't hear myself all the way. So hopefully I don't sound too crazy. Let's see what's going on in the chat. We have Marianne Williams saying hi, Bree and Bree Hive. Hope everyone is having a relaxing evening. A member of our channel, hello, welcome back to the live stream. Thank you for joining in with us. Tanya D says hi to Marianne. Hi, Bree Hive. How was your day? Yes, how is the day going? We are on Tuesday. I was just saying, the week is going by fast but slow. I don't know how I feel about that. Marianne Williams says hi to Tanya D. Great now that work is done. Yes, getting done with work is the best feeling. Tanya D says, I hear you. I'm still working to get some things done before I go out of town on Thursday. Ooh, I hope it's a fun trip out of town. Tanya says, one more email to send, then I'm going to attempt to make my first rhinestone shirt. Oh, that's fun. I wish I was crafty. I'm not crafty. I wish I was. So I would love to see it when you're done with it. Deacon Fado says, hi all. Hope everyone had a good Tuesday. Yes, hello, Deacon Fado, another member of the channel and moderator of the channel. Welcome in. Saying hi to Tanya and Mary Ann. Happy Tuesday. Yes, we are making it through the week. There's just spice in the air. So if I choke y'all, I'm sorry. Like, I'm feeling the spice in my throat. We just had some spicy food and it's in the air and it's in my throat. So if I choke on the live stream coughing, I'm sorry. All right, Deacon Fado here live saying we made it. Yes, we did make it to Tuesday. We are back here. Asher Mama, hello. Welcome back to the live stream. Nice to see you. Alicia G, another member of the channel. Welcome back to the live stream. Saying hi, Bree, and dropping a membership emoji, and saying happy to be here with you. Like Bumblebee, that's cute. All right. Everyone saying hi, hello, welcome in. Swat Watson, another member of the channel. Welcome in. Nice to see you. Tiny D said, hey, Bree, your hair is cute. Oh, thank you. We switched it up. Thank you very much. I don't know how long I'm going to have this one, but I got to figure out what else I could do next. But I'm glad you like it. Z Seltzer here live. Welcome back to the live stream. Nice to see you. All right, let's see. Everyone saying hi. Jane Stoddard says, hi, Bree and Bree Hive. I've been watching the Gwen P trial with the lawyers today. Yes, I have not been paying attention to that too much because I've been having to work. But I have seen that some of the other lawyers on YouTube has been covering it. So I might check that out later. I don't know exactly what it's about. Isn't it like she ran into someone on her skis or something like that? Paula Mayha says, hey, hello. Welcome to the live stream. Nice to see you again. Another member of the channel. Cheerful Bacon, another member of the channel saying, hey, Bree and Hive. Hello, welcome back. Paula Mija said, made it to another live. Hope everyone is doing well. Happy Tuesday. Meanwhile, crazy windstorm here in the Bay Area. Is it not crazy? Like, it is absolutely crazy. I was thinking that on my way home. I felt like it was going to blow my car over. I'm not in the Bay Area, but close enough. It's windy down here, too, in the Sacramento area. Robert Hines says, hello, Bree. Hello. Welcome to the live stream. Okay, we got some memberships getting gifted in here. Tanya D says, welcome, everyone coming in. And then says, stay home. Yes, stay out. Stay safe. Stay safe. Yes, out of the way of the wind. It's crazy out here. Deacon Fatal says, hi, Cheerful Bacon and Robert Hines. Paula says, thanks, homebound. I ain't driving anywhere. Yeah, that's how I feel. I just want to stay put where I'm at. Okay. I am trying to find a message from Marianne because Marianne just gifted one Boss Attorney Bree membership, and it was given to, let's see here. Oh, we got 2 Boss Attorney Bree memberships gifted by Marianne. Thank you so much for supporting the channel and allowing more members to join in with us. Hopefully, these members will also join us on the members live stream. Okay, now I can't make it disappear on studio, but I see Ren Campbell was gifted a membership, and I can't see the other one because I don't, oh, yes, I can. I can see it. Robert Hines was gifted a membership, so welcome to the Bree Hive membership. You get cool badges next to your name and cool little emojis, so I hope you enjoy it. And then we also do a member stream. We're trying to do it once a month, so hopefully you can join us then. All right, let's get into these cases. It felt like a long intro, but it really wasn't that long. So sorry if it felt long to you guys. All right, let's go ahead and check out. We're going to go ahead and start with the mac and cheese case because it was highly, highly requested. So let's go ahead and see what's going on there. For those of you who do not know, basically a lady sued the Kraft Heinz Foods company over their Velveeta microwavable mac and cheese. I gotta know, do you guys eat that mac and cheese? Do you like the mac and cheese? Have you guys ever tried their Kraft macaroni and cheese? I cannot stand Kraft macaroni and cheese, so I would like to know if you guys like it. But anyways, she was not happy because she bought the microwavable mac and cheese and it was not done in 3 minutes like the packaging promised. So she's saying that it's misleading and she filed a class action just like the guy from last week over the boneless buffalo wings. Following the lawsuit on behalf of himself and other people similarly situated. So let's see what she has to say. What are her complaints? What is she going to allege here? Let's see. We are in the United District Court, Southern District of Miami, Southern District of Florida, Miami Division. I am telling y'all, the spice is getting to me. Like my nose and stuff, my ears and stuff. I don't know what to do. Okay. We have Amanda Ramirez individually and on behalf of others similarly situated suing Kraft Heinz Food Group, asking for a jury trial as a class action. Plaintiff alleges upon information and belief, except for allegations about plaintiff, whose are based on actual knowledge. It's kind of cut off here. Let me get it together here. All right. Factual allegations in this case. Kraft Heinz Food Company manufactures, labels, markets, and sell microwavable single-serve cup of mac and cheese represented as ready in 3.5 minutes. So not 3 minutes, guys. We're talking about 3.5 minutes under the Velveeta brand. They're going to refer to that as the product. Have you guys tried the microwavable one or do you just do the one on the pot? I don't even know because I don't eat these things. So I don't know how many different ways this thing comes. All right. The statement of ready in 3.5 minutes is false and misleading because the product takes longer than 3.5 minutes to prepare for consumption. How long is she alleging that this thing takes? According to the directions on the back of the packaging, there are 4 steps to preparing the product. They're going to let us know how to make microwavable macaroni and cheese. Here's the product here. The label here saying the directions. Remove the lid and cheese sauce pouch. Add water and fill to the line in the cup and stir. Let's see. Uncover on high for 3.5 minutes. Do not drain. Stir in contents of the cheese packet. Let's see. They say they got some starch blend in a cup, reduces risk of boil over. Cheese sauce will thicken upon standing, and do not reuse the cup. Okay, giving us some pretty good. Oh, it literally spelled it out for me. I read it all off of the small label. That's okay. That's okay. That's okay. All right. The cheese sauce will thicken upon standing. So I'm guessing that's what they got the problem with. Because if you're saying it's ready in 3.5 minutes, but you have to put it in the microwave for 3.5 minutes and then let it wait for the cheese to thicken, I see her point. I see her point. Okay, let's see. Consumers seeing ready in 3.5 minutes will believe it represents the total amount of time it takes to prepare the product, meaning from the moment it is unopened to the moment it is ready for consumption. I see her point. Is it worth suing? I'll let the chat determine that. Okay, however, the directions outlined above show that 3.5 minutes is just the length of time to complete one of several steps. The label does not state that the product takes 3.5 minutes to cook in the microwave, which would have been true. I don't even know if that would have been true, but let's see. To provide consumers with a product that is actually ready in 3.5 minutes, the product would need to be cooked in the microwave for less than 3.5 minutes so that all the preparation steps could be completed in the 3.5 minute time frame. Okay, but are they going to sit there and like time people and like, no, you can't check your phone, you can't do anything because this needs to be made in 3.5 minutes. If you skip any step or delay any step, it's your fault, and that's why you're gonna be. I mean, I guess if you're reading it quite literally, I get her point. Don't know if it's worth suing over it. Let's see. Just make your own mac and cheese if you have such a problem. All right. Consumers are misled to expect that the product will be ready for consumption in a shorter amount of time than it really takes to prepare. Defendants sold more of the product and at higher prices. Here we go with this higher prices thing. How much money did you really lose from doing this? Let's see. Defendants sold more of the product and at higher prices than it would have in the absence of this misconduct, resulting in additional profit at the expense of consumers. As a result of the false and misleading representation, the product is sold at a premium price, approximately no less than $10.99 for 8 2.39-ounce cups, excluding tax and sales higher than similar products. Let's see. Where are we at? Represented in a non-misleading way and higher than it would be sold for absent the misleading representation and omission. I'm kind of under the impression that they would have sold it at that price no matter what because of their brand recognition, more of like because of their trademark, not because it cooks faster. That's what I would assume they're offering as the price point, but who knows? I'm not in their marketing team. Let's see what the chat is saying so far. Let's see. We have Hella Swanky. Welcome in, chatting with Deacon Fatal, saying, what's good? How are you? Nice to see you, Hella Swanky, in the chat. Another member and moderator of the channel joining us today. Deacon Fatal says to Palomija, I really need to look up EM again to see what has changed. And I don't know exactly what y'all are talking about, but let's see. Tanya D says, there you are, the Hella Swanky. Good to see you. Yeah. We missed you at the beginning of the chat. Deacon Fatal says to Hella Swanky, just hanging out for a bit. They're going to start working on a score for an audiobook. Oh, nice. Paula Mija says, nice. I mean, I have stuff in my car like a blanket, emergency kit, garbage bag, utensils, scissors, bags, extra jacket, but no water unfell, LOL. I don't have all of that stuff in my car, but that's probably a good idea. Let's see. You're doing it right. Hello, Swanky says, just reminding me I need to check your Discord message. Oh, gosh, you guys are having a whole conversation. Let me not put your conversation on blast here. Tanya D says, I think I tried it once years ago when it first came out. As far as the macaroni and cheese, Paula says, sad I have a wine opener, but not water. Laughing my AL priorities were a bit wrong. Hey, you never know when you're going to need some wine. The time, oh, you guys has got time. Side combo. Thank you for letting me know. Deacon Fado says, was able to get the new monitor set up now to read the short story. Nice, nice. Deacon Fado says to Tanya, oh, she loved it. Oh, you guys are talking about the shirt. As your mama says, these lawsuits are so ridiculous, they crack me up. Yes, they are. Marianne says, can I call BS? Yes. Did she actually buy it and really time? I mean, I guess it sounds like she just looked at the package and was like, nope, this is not going to be ready in 3 minutes. But she would have needed to buy it in order to be harmed by it. Let's see. I am trying to find the where I'm at. They're talking about the parties. I'm just trying to find where I need to be in the lawsuit, and then we'll go ahead. Yes, BS for sure. Tony D says they really are to Asher Mama's. Deacon Fado says, but I am happy to say she enjoyed the meal and company. Okay, you guys are hanging out with the grandparents. That's nice. Hello, Swanky says, me too to Tanya D. I think you guys are having a whole combo. I think you're talking about weather. I like to hear about the weather. Let's see. Had to go out in the storm. It's freaking storming in the Bay. I'm so irritated. It's pouring in Oakland in March. Hoping this will turn my mood around. Yeah, it's crazy. It's crazy around here. Let's see. Hello, Sorgy says, agree with Asher Mama 100%. People will sue over anything. At this point, yes. Lambe Bay says, hey, everyone. Hello. Welcome back to the live stream. Nice to see you. Robert Hines says the 3.5 minutes is probably a typical time because microwaves vary in power. Yes, that is true. Usually there's a little note on there that says that, like the popcorn that I made yesterday, that was pretty bad because it was really salty. It literally said like 1.5 to 5 minutes because microwaves vary. I'm like, that is a large gap of time. 1.5 minutes up to 5 minutes to make popcorn. Ridiculous. But yes, microwave speeds and heat does vary. Tiny D says, so did it take 4 minutes instead of 3? Sounds like it probably took like 5. Probably 5. That's what I'm going to go with. I don't know. Maybe she'll let us know later on how long it took her. Lambe Bay says, is this the one where because they didn't add the preparation time, it was over 90 seconds? Yes, that is this one. That's what we're talking about today. Let's see. Plaintiff seeks certification for the class action. There's a Florida class and then the multi-state class. I think we're going to skip over this because who cares? Let's see. Unfair practice. Let's see. The first cause of action they have is Florida deceptive and unfair trade practices. Let me see. I think it only said it's because it took longer than the 90 seconds. So defendant violated and continues to violate Florida's Deceptive and Unfair Trade Practice Act by engaging in unfair methods of competition, unconscionable acts and practices, and unfair and deceptive acts and practices in the conduct of its business. Defendant misrepresented the product through statements, omissions, ambiguities, half-truths, and or actions that it would take 3.5 minutes total to prepare and be ready for consumption. Yeah, so they're mad about the prep time. The material misstatement and omissions alleged herein constitute deceptive and unfair trade practices, and that they were intended to and did deceive plaintiff and the general public into believing that the product would take 3.5 minutes total to prepare and be ready for consumption. Plaintiff and class members relied upon these representations in deciding to purchase the product. Plaintiff's reliance was, I guess she did actually buy it. Plaintiff's reliance was reasonable because the defendant's reputation as a trusted and reliable company known for its high-quality products honestly marketed to consumers, which is the true reason why I think their price might be higher than similarly situated products. It's simply because of their brand name. People know Velveeta. People knows the Heinz food company. So I highly doubt, or Kraft Heinz Food Company, I highly doubt whatever the price difference was based on the cook time, but rather based on their brand name. Because you can get like the Great Value brand, and it's a whole $1.50 cheaper, even though it's probably made in the same factory, allegedly. And it's more of the name. You can charge more because of the name, because of the reputation, right? So let's see here. Plaintiff's reliance was reasonable because of plaintiff's reliance was reasonable because of defendant's reputation as a trusted and reliable company known for its high quality products. Plaintiff and class members would not have purchased the products or paid as much if the true facts had been known, suffering damages. How much faster or how much longer did it take? How much difference in time should it cost? That's what I would like to know. Are they asking for like 50 cents because it didn't get done as fast? Like, I'm confused. What exactly is she asking for? Let's see. Defendant's conduct offends established public policy and is immoral, unethical, oppressive, and unscrupulous. I don't know how to say that. To consumers. Plaintiff and class members are entitled to damages and the amount to be proven at trial. I don't know how much you guys are going to get out of that. Defendants should be also ordered to cease its deceptive advertising and should be made to engage in a corrective advertising campaign to inform consumers that the product takes longer than 3.5 minutes total to prepare and be ready for consumption. So they don't want them to just say, hey, it actually takes 5. They don't want them to change the packaging and say, oh, it takes 5 minutes. They actually want them to go on a freaking press release to be like, hey, you know what? We lied. It takes more than 3.5 minutes. You're probably going to be preparing this thing for 5 to 7 minutes. Like, what do you want from them? All right, let's see. Let me go ahead and go in the chat and see what the peeps are saying. I'm so sorry, y'all. My nose is so stuffy right now, and I feel uncomfortable. Let's see. Where were we at? In the chat. Let's see. All right. We have Hella Swanky saying the Deacon Fatal. Yes. And Mood Fix. Also, I got to tell you about the show. First time in a pit with my wheelchair. I was worried, but it all worked out. I'll send videos on Discord though. Y'all got a whole little chat going on. Lambe Bay says she was mad because the 3 minutes didn't include adding water and I'm putting the cheese in for it to thicken. That's what she was mad about. So it's actually Cheerful Bacon says 4 to 5 minutes in my microwave for popcorn. That is a long time for popcorn. I was like in shock. One, that it was that big of a time gap, and two, that some people, including Cheerful Bacon, has to wait 4 to 5 minutes for the popcorn to get done. That's crazy. BRB. Lambebe says, I'm great now that I'm here recovering from a back injury in need of a few good laughs. How's everyone else doing? Well, happy to have you here. Happy to hopefully provide you with some laughs to recover from the back injury. Cheerful Bacon says, I gotta run, but look forward to catching up on Replay Crew. Well, thank you for stopping by live. Tanya D says, more side combo. I'm going to skip it. Ashley Mama says, how much are they suing for? They don't know yet. It's to be determined at trial. I want to know, like, how much difference is this 2 minutes costing them for their life? I don't know. Hello Swanky says, by the way, shout out to the already gifted members from Marianne Williams to become an official Brihai member. Hit the join button on Android and desktop. Thank you as always. Hello Swanky promoting the membership. As stated before, you get cool badges and cool emojis that you get to use in the chat. And you support the channel and get to come on our members live stream. And guys, I think we're at like 100 and something members right now. So thank you everyone that supports the channel and that have become members. Okay, let's see. Let's see where we at. Marianne Williams says prices vary from state to state. Also, it's like $8 for an 8-pack of Velveeta here. Yeah, so that's also going to cause some changes there. I want to know how much she's valuing her 2 minutes at. Is she basing it off of like her hourly rate at work, or like what is she basing it off of? Deacon Vado says, I think we will need a reader also. I'll ask the author. You guys are talking about the book. Always love reading. Get paid to read. That sounds good. Tanya D says, goodness, Bree, what did you eat? I ate African food is called okra stew that Alpha made. And it has like a whole bunch of habanero peppers in it, and like the spice smell is just in the air. And it's like, I don't know, it's just like it closed up my ears and my throat. And I'm all stuffy. So I'm sorry if I sound congested to you guys. And also, as you guys know, Alpha was also sick. So I don't know if I'm getting sick or if it's just the spice. But we'll find out once I get off of live. Hello Zoiki says, nah, we're done, Bree. Just a quick catch up. It's been a while, but we're paying attention. Promise. No, it's okay. Have fun in the chat. I love the chat. Oh, you're on. Linika Story says, hello. Welcome to the live stream. Nice to see you. Welcome in. Paula says, this lawsuit is ridiculous. Yes, it is absolutely ridiculous. I don't think I'm going to read through all the other causes of action because it's going to allege similar things, and we're still not going to know how much money they're actually asking for. But yeah, it's ridiculous. She's mad because it takes more than 3.5 minutes to make this macaroni and cheese. Maybe she only has a 10-minute break on her lunch and she needs to get it done. And if that's the case, she needs to be filing some complaints because you're supposed to have a longer than 10-minute lunch break. Okay. I'm just making stuff up. Don't quote me on that. Tanya D says, yay, over 100 members. Yes, we are over 100 members. Yes, we are. Thank you so much. And hopefully we're on our way to the 50K subscribers. I'm excited about that. Deacon Fado says, is Velveeta real cheese? Questions that need answers. I literally only use Velveeta cheese to make rotel. I'm not using Velveeta cheese for any other purpose. I know people that do. I go more on that it's not real. That's I would say that it's not real, but I guess it's edible, so it has to be some kind of real. All right, y'all having combos. Oh, nice. DiCapito says, I just learned about Dish today. Okay, you guys are talking. Marianne says, yay, yes. Hello Soiki says to Linnea Story, hey there, welcome to the Brie Hive. Hope you're well today. Yes, of course. Tanya D says, well, I'm glad to hear Alpha is feeling better. Yes, he's feeling better and cooking, so that's good. But now my congestion is coming in, so hopefully I don't get sick. Carrie Todd said, popping in, thankful for the replay. Well, thank you for popping in. Nice to see you. I hope everyone's doing well. Yes, I hope you are also doing well. Robert Hines says she probably could have sent a letter to Kraft to complain, and they would have sent her a case of them as an apology. They really do that. Like when you complain about stuff, they just send you a bunch of it or like a coupon for it. It's absolutely ridiculous. I remember I complained about like a Sierra Mist one time, and they sent me a coupon to get like 2 12-packs. I'm like, I don't want more. I wanted it that day when I ordered it from the vending machine, and it didn't give me one. I don't want a 12-pack 2 weeks later. It's ridiculous. And I was like, no, I want my money back. I think it was like $2. And I was like, no, I want my money back. I don't want more of your product. And they gave me my money. I think they ended up giving me like $10. But they're like, the value of the sodas is a lot more than what you spent. I'm like, F you, bro. I want my money back. I don't want your stupid coupons. Oh my gosh, it was from Pepsi. Has that ever happened to you guys? I was so shocked that happened to me, but it did. They sent me some freaking coupons. Deacon Fado says they really do. Alice Wakey says, I believe Velveeta is made with real cheese. It's not pure cheese. I could agree with that. Marianne Williams says real cheese food. Right. Deacon Fado say hi to Carrie Todd. Uncivil says Jack Daniels case is the best case. Have you covered it already, Uncivil? Kurt, I think I touched on it before, but I haven't gone deep into it. So let me know if you have already checked out the Supreme Court aspect of it, because that's what we're going to be looking at today. Everyone's saying hey to Kurt from Uncivil Law. Lambe Bay says, if it's not real cheese, I don't want to know. Do we want to look it up? Because let's be for real. how do they put that cheese on a shelf? And usually cheese has dairy in it, right? Cheese has dairy in it. And I don't think you're supposed to leave cheese out or any other kind of dairy out on a shelf. So something about it is not real. Some preservatives, don't know what those preservatives are. Ashley Mama says that case cracks me up too. Well, we are gonna jump into it. The dog toy case. Marianne saying hi to Uncivil. Uncivil says, I am almost done on my stream, Boss Attorney Bree. I am going to send you a raid in about 20 minutes. Keep crushing it. Oh, well, thank you. Thank you so much. I hope they come over and join us for the case. How are you commenting and streaming on your own stream? I cannot double task like that or multitask like that. Let's see. Hello Swanky says, does anyone else watch from the beginning on like 1.75 times 2 speed until you catch up whenever you're late to a live? Just me. Sometimes I do that, other times I don't. Just depending on how far they are. Z Seltzer says, when Emily D. Baker read this, she found that the lawyer for this case bases his whole practice around these kinds of lawsuits and is on 100 of products of false advertising cases. It is now raining very hard, so hopefully you guys can't hear that on the mic. I don't think you should be able to, but it's pretty hard. Yeah, so I was thinking that same thing about the case that we had on Thursday. It's like he has to be using the same lawyer because he had like 3 what I would consider frivolous lawsuits. So I would not be surprised if it's the same lawyer filing all of these false advertising claims. And the thing is, these big companies probably just settle because technically they are misleading, they are lying, and people do rely on the things that they say. So you're probably just going to get a settlement anyways, unless the court decides to throw it out. I'm not too familiar with these kind of cases, so I don't know if this is likely to be thrown out or not. I just like the food drama of it. But I would love to see how these ones play out. Both the boneless wings ones, that one they may be able to ask for a little bit more money. But again, when we talked about it on Thursday, I don't really see that much money that they can get out of it, to tell you the truth. But also with this one, how are you going to value the extra 3 minutes that it took you? I don't know. I really don't. Lambe Bay says, is the Jack Daniels one the one with the motion filed with the connect the dots attached? I don't know about that, but this is the one where there's a dog toy company selling Jack Daniel like toys, and Jack Daniels, the alcohol, does not want to be associated with dog toys. Deacon Fatal says, oh, there was a butterball complaint about turkeys last Thanksgiving. Really? that one sounds good. I want to look into that. We're going to be food streaming over here. And Sybil with a smiley face. Lady Autumn Sky says, hey, Bree. Hey, chat. Been listening while getting ready for bed. Well, thank you for joining in, another member of the channel. Uncivil says, can you grant me redirect permission in your YouTube studio setting, please, Bree? If I can figure out how to do that while streaming, let me go into studio. I think I looked at this the other day, but I can't remember where it is. I think it's sorry y'all, we having a brief break here so that we can get some friends from Kurt's stream when he's done. Let's see here. I'm trying to remember how to do it. I think it's settings and then channel and then let's see, permissions maybe? No. Community. Here we go. Here's the community, moderators, approve user, hidden users, specific channels who can redirect to my content, uncivil law. Let's see, I found it, so let's do it. Oh, there you are. I tried to do everybody at one point, but it wouldn't when I first had my channel, so you should be all good now. Let me know if you can find it. Now I'm trying to get back into my stream here. I'm already yellow flagged on this stream. How ridiculous. Okay, Kurt, I did it. Let me know if it worked. Hello Swanky says, let's see. Oh, raid incoming. Thanks for the heads up. Yes, we would like the raid. We are trying to get to 50K. Okay. So we want the raid. Taya D says, have a good night to Lady Autumn Sky. Destinene, welcome back to the live stream, saying it makes the best mac and cheese though. LOL. So you like the Kraft mac and cheese. I don't know if I'm a fan to that. I don't know. You guys like it? Okay, Carrie Todd says the velvet's orange color is not natural. Right? It's the leaving it on the shelf for me. I don't know how I feel about that. Deacon Fiddle says we are Pavars brie. We don't deserve real cheese. Why? I want real cheese. I like real cheese. Elisaki says to Destinene, the best question mark. I don't know about the best, but dang good. You're right about that. Astronomic says, I don't trust Velveeta. Not this turning into a Velveeta bash stream. Let's see. Let's see. Can't hear. Oh, you can't hear me? Can you guys hear me now? Let me see. I went away for a while. It says my microphone is working. I don't know if that was a while ago, but hopefully you guys can hear me or could hear me. Let's see. Oh, Swanky says to Asher Mama, LOL, I don't blame you, but Destinene is right about making some dang good mac and cheese. Much tougher to make in the good without Velveeta cheese. I know people that use Velveeta cheese. I personally don't to make my mac and cheese, but I have had some that was good that way. I use it only for Rotel, to tell you the truth. I'm not going to give I don't know. I just don't trust them, but that's okay. Oh, I mean, like in America, what food can we really trust? So I guess it's all questionable if you ask me. Asher Mama says, I do love good mac and cheese, but I haven't tried Velveeta. The Velveeta mac and cheese that I have tried, not like the Kraft's Velveeta one, but like when people use the Velveeta cheese within like their homemade recipe, it just uses it to make the sauce, but not necessarily for the full mac and cheese, the full thing. So it uses some Velveeta and then some real cheese. Not real cheese. Yes, real cheese. Okay. Cheryl C, hello, welcome back to the live stream. Nice to see you. Deacon Fiddle says, I do want to hear more about Jack Daniels' case. We are going to get into that. I did not realize I was so far behind in the chat, so I'm going to skip some chats, catch up on that, and then we'll get into the Jack Daniels. We are fast forwarding way ahead because we are not going over like the complaint. We're going straight to the Supreme Court. I feel like I did. Like a part of me feel like I covered this on my channel briefly, but not like a full stream on it. But maybe I'm thinking of other people's channels. So maybe I'm lying. I don't know if I covered it or not. Let's see where we're at here. Deacon Fatal says, I can't say it's horrible. I just don't think it's real cheese, right? Right. Hello, so like it says, no, people use Velveeta and their real mac and cheese with other cheeses. Yes, I have had it like that. Yes, for sure. Nick M says, Boss Attorney Bree, there is a copy of the Connect the Dots for the Justices post on Bloomberg News. Oh, I will have to find that. Marianne says, no, we can't hear the rain. Oh, I was so confused. I was like, you guys can't hear me? I was like, because I went out of the studio for a minute. Deacon Fatal says CC and is working also. Okay, perfect. I've been doing good at making sure I'm turning on the closed captioning. Okay, can't hear the rain. Okay, good. Hello, Soinky says we were not talking about Kraft box stuff, or at least I wasn't. I was talking about real mac and cheese. People put Velveeta in their baked mac and cheese. Yes, I have had it like that. Yes. Cheryl C says, same Velveeta and Rotel equals perfect. LOL. Oh my gosh, I want some now. Destinene said, black people doctor it up. LOL. Yeah, that is true. Deacon Fatal says, that's true because milk shakes. I don't know about leaving cheese on the shelf. And Velveeta is low-key expensive for no reason. Like a block of Velveeta is like $8 at this point. It's expensive. And that makes Rotel expensive. Okay. Lady Autumn says Velveeta too expensive in my opinion. I clicked on the chat, but I hadn't read it yet. But yes, it is low-key expensive. Hello Smokey says I can hear the rain because it's beating on my window in March in California. Okay, I'm done. I'm fine. All good. Yes. The rain is like they're like big drops or something because they're loud. They are loud. They are loud. Okay. Want the URL. For the story you're talking about, yes, if you have it, that would be cool. That would be cool to connect the dots. Lom Dave Day says this is the one with the connect the dots. Emily D. Baker went over this, and there was like 45 different ones. They were hilarious. Okay, yeah, I have no idea about that. I literally just pulled the Supreme Court petition. And we're just going to hop around in that. Okay, let's get into it. I've been chatting, playing around in the chat for the last 10 minutes. But that's okay. We have fun in the chat. We love the chat. All right, let's check this out. Let me get to the top of the page. Okay, we are talking about the Jack Daniels. This is a trademark lawsuit, y'all. So we are going to be talking about it in trademark. Jack Daniels is upset because this doggy toy maker, doggy toy maker is using Jack Daniels to kind of play on their toys. And Jack Daniels is not having it. They do not want to be associated with little puppies. They want you to get licked. They don't want to be associated with little puppies. All right, let's see. Questions presented. Respondent VIP Products LLC markets and sells dog toys that trade on the brand recognition of famous companies such as Petitioner, Jack Daniels Properties Incorporated. The district court found that VIP's use of Jack Daniels trademark to sell Why does this keep coming up? To sell poop-themed dog toys was likely to confuse consumers, infringe Jack Daniels marks, and tarnish Jack Daniels' reputation. I said, why does this keep coming up? Because I was on Rob's channel 2 weeks ago, and we covered unicorns that were all about being poopsies. So now we're doing it on my channel. I did not intend this. Oh man. All right, Deacon Fatal, thank you so much for the super chat saying, yes, I will pay $8 for gas and ingestion for Velveeta cheese. Is that what you're referring to? Oh my gosh. Thank you so much for the super chat. Yeah, we gotta get it off the shelves. Get Velveeta off the shelves. That's what that lady wants. Get it off the shelves. All right, let's see. The Ninth Circuit, however, held that VIP's First Amendment interest in using Jack Daniels' trademark as its own mark on funny dog toys conferred special protections from infringement claims and rendered VIP's commercial dog toys non-commercial and thus exempt from dilution by tarnishment claims. The questions presented are: is it not commercial? Maybe it's not commercial and competing in the same realm as Jack Daniel liquor, but it is commercial because are they giving them away for free? I don't think so. That would be a bad business model. But this is kind of similar to what was the case that we covered that this was similar to the Meta Birkins. Is this a First Amendment protected right? In Meta Birkins, they said no. In this case, let's see. Let's see what the Supreme Court says. Okay. These are the questions for the Supreme Court. Whether humorous use of another trademark as one's own on a commercial product is subject to the Lanham Act traditional likelihood of confusion analysis or instead receives heightened First Amendment protection from trademark infringement claims. I think that is a dangerous road to go down. So I'm hoping that they say, hey, you're going to be subject to trademark infringement. They're going to try to argue like parody, playfulness, right? Whether humorous use of another's mark as one's own on a commercial product is non-commercial under 15 USC 1125, thus barring as a matter of a law a claim of dilution by tarnishment under the Trademark Dilution Revision Act. I think that is going to make dangerous waters if they say that people can do the humorous trademarks, because that is dilution. That is going to be, okay, well, Jack Daniels sells good whiskey, but now all of a sudden they're selling poopy dog toys. they're going off into the wrong realm. I don't know. I think Jack Daniels has a point in bringing this lawsuit. Let's see. Where we at? Corporate disclosure statement. Petitioner Jack Daniel Properties. Oh, we're not reading that because it's a basic statement. Where are we at here? I'm going to skip around in this. Let's see where we at. We're going to go through the facts and then we're going to go through the reasons. Probably not all of the words, but let's go through the facts, which I think it said it was on page 9. All right. While I do that, I'm going to go ahead and check out what some of the peeps are saying. Tiny D says, no, I don't to Nick. Did you see the link? I think that's what they were talking about. Marianne says, okay, so if they hadn't sued, it would never have known. I would have never have known about this case. What is that called? Like the Streisand effect? Yeah. I would have never known about it either, but I don't have dogs, so I wouldn't have known about it. Deacon Fatal says, to me, Jack Daniels have some other stuff going on with their brand. I don't know. I don't know exactly what you're referring to there. They just have this trademark lawsuit of this doggy toy trying to sell little doggy toys of poopy doggy toys. Let's see. Where are we at here? Let me go ahead. All right, get into the statement of facts. What page am I on right now? That's page 5. Okay, so let me go ahead and show you guys what this thing looks like. Let's see. Can you guys tell the difference of which one is which? Can you tell the difference of which one is which? All right, so we have the whiskey on the left side, and we have Bad Spaniels on the right side. And the district court found that the Bad Spaniels toys was likely to confuse consumers and tarnish Jack Daniels' mark. I would agree with that. What is it? Just like a chew toy. That's what it looked like, right? Yeah, I think so. Let's see. I wanted to get into the facts. I don't want to go through what happened in the lower courts. We could go through that at a different time. Let's see where we at. All right, factual and procedural background. Petitioner Jack Daniels owns and licensed the trademark and trade dress associated with Jack Daniels Tennessee whiskey. The Jack Daniels Distillery in Lynchburg, Tennessee, is the oldest registered distillery in the United States. Jack Daniels Tennessee whiskey has been sold for over a century, except during Prohibition since I like how they put that in. Except during Prohibition, we were not illegally selling alcohol during Prohibition because that was illegal and we were not doing that. I like how they put that in there. Jack Daniels has been the best-selling whiskey in the country since 1997. Wow, did not know that. I don't really drink whiskey like that. Since 1975, Jack Daniels Tennessee whiskey has borne the registered trademarks Jack Daniels and Old No. 7. Jack Daniels also has a registered trademark for its 3-dimensional configuration of a square-shaped bottle with embossed signature Jack Daniels. Now, they also have the trade dress. So, not only do they have the trademark Jack Daniels, which the defendants put a spin on by calling it Bad Spaniels and putting a little Cocker Spaniel on there, but they also have the trade dress. They have it registered as that shape of the bottle. And as you guys saw, the toy is shaped just like the actual bottle for the alcohol. So I see why Jack Daniels is bringing this. Hundreds of millions of dollars have been spent promoting Jack Daniels whiskey. Approximately 98% of consumers express awareness of the Jack Daniels brand. That's true. Jack Daniels maintains an active brand licensing program as relevant here because they could have paid Jack Daniels to make this product and they did not. As relevant here, Jack Daniels licenses its trademarks and trade dress for pet products, including dog leashes, collars, and houses. So it is conflicting with products that is associated with Jack Daniels because Jack Daniels allows other toy makers to use the trademark on their toys, on their dog houses, on their collars. So now people are going to think you're making bad spaniels instead of Jack Daniels toys. Responded VIP designs, manufacture, markets, and sell chew toys for dogs. Its Silly Squeakers product line consists of rubber dog toys designed to profit off consumers' familiarity, I cannot say that today, with well-known brands of liquor, beer, wine, and soda that include sometimes dog-related, often poop-related humor. Examples include dog toys labeled Smella our crotches. Oh, wow. Henny Sniffin for Heineken, Pissness for Guinness, Mountain Drool for Mountain Dew. Okay, formerly VIP sold a butt wiper dog toy mimicking Budweiser. Are they serious right now? I guess I did not cover this on my channel because I was not familiar with this at all. Okay. In 2008, a federal district court preliminarily enjoined VIP's sale of its butt wiper toy, finding that Anheuser-Busch had demonstrated a substantial likelihood of success on its claim for trademark infringement. Undeterred, VIP in 2014 began selling its Bad Spaniels toy. Bad Spaniels copy the distinctive square bottle and black and white labeling of Jack Daniel's Tennessee whiskey. There we have it. I think you guys already said it does look pretty similar, right? Let's see here. As these images make clear, Bad Spaniels appropriates Jack Daniel's mark and trade dress in virtually every way. The toy replaces Jack Daniel's with Bad Spaniels, along with the image of a spaniel. It replaces Old Number 7 Tennessee Sour Mash Whiskey with Old Number 2 on your Tennessee carpet. What? And it replaces 40% alc by volume, 80 proof, and with 43 poo by volume and 100% smelly. The remaining features the square bottle shape, ripped neck, lettering, filigree border, color scheme, font style, and size are nearly identical. The backside of the Bad Spaniel label states in tiny font, this product is not affiliated with Jack Daniel Distillery. It's already too late. It already looks like their bottle, and then you like literally copied the labeling. Yeah. Imagine like leaving your actual real bottle of Jack Daniels on the floor and then your dog sees it and tries to chew on a glass bottle. I don't know. Maybe dogs are not that silly, but I think of that. All right. Tiny D says, really? How oh, you guys are talking to each other. Deacon Fatal says, you know what? I got this confused with Jack Daniels versus Uncle Nearest. That's my bad. Nick M says, if they have been getting away with this, why now? Yeah, they're saying since 2014, but it usually takes a while for these cases to come through the court. So this case has probably been going on for a while, but I probably should have checked that before I streamed this. Z Seltzer says, I live in Cleveland and watching bad snow drivers is a thing most people out here just learn. Yeah, people act like they don't know how to drive in the rain around here. Lambe Bay says, it'll be deconstructed mac cheese, Jack Daniels, and puppy party, but bring your own pee, bring your own puppy, right? No, Lady Sky says, like Lady Autumn Sky says, Tiny, yep. But people are allowed to purchase as part of the distillery tour only. Hello Swanky says to Destinene, we also had to do that. And yeah, I can't think of a time I've needed that too, but you never know. At least your parents did more than just the basics. Nick M says, Old Number 2. Yes, they said Old Number 2. Destinene says, yeah, these people knew what they were doing. They're all the way copying. They're playing off of it for sure. They're playing off of it. Tiny says, wow, way to corner the market, right? Destiny says to Hella Swanky, will be good get away drivers, I guess. Good getaway drivers. Bring some deconstructed wings. Oh yeah. Where's the business plan for the deconstructed wings restaurant? Let's see. Okay. Oh, I'm struggling through this stream, y'all. So thank you for struggling through it with me. The district court found that VIP's intent behind designing the bad spaniels or design it's they put design. Let's spread out, and I said designing. Designing the bad spaniels toys was to match the bottle design of Jack Daniel's Tennessee Sour Mash Whiskey. VIP's president coined the same bad spaniels and asked the company's designer to propose the design. The designer understood that bad spaniels referred to Jack Daniels. She retrieved a Jack Daniels bottle from her liquor cabinet. Not you went and got your own bottle of Jack. Like, you could have at least went to the store and bought one, not having it on reserve in your own cabinet. Okay, she went to her closet or she went to her cabinet, got the Jack Daniels out. Instead of like looking at a picture of it online, right? Okay. She retrieved the Jack Daniel bottle from her liquor cabinet, examined it, and placed it on her desk while sketching the design. Do they not check on trademarks before they do stuff like this? Jack Daniel has a whole trade just for the bottle. Like, are you serious? There are not a lot of bottles that I don't think there's any liquor bottles that shaped like Jack Daniels other than Jack Daniels. So that was not a good idea. People are crazy. Let's see. After VIP introduced Bad Spaniels in July 2014, Jack Daniels promptly asked it to stop selling the toy. VIP responded by suing Jack Daniels. How are you going to sue them? It's their trademark. Okay. VIP responded by suing Jack Daniels in the U.S. District Court of Arizona, VIP's home forum, seeking a declaratory judgment that Bad Spaniels did not infringe or dilute any trademark rights. Jack Daniels filed a federal and state law counterclaim for infringement and dilution by tarnishment. VIP moved for summary judgment, and Jack Daniels cross moved for partial summary judgment. So basically, instead of arguing with Jack Daniels, VIP, the dog company, decided to sue them so that the court can tell Jack Daniels about themselves, letting them know that it's not actually trademark infringement. Jack Daniels then turned around and sued them and was like, no, you're wrong. It is trademark infringement. So summary judgment for you. And now we're all the way to the Supreme Court. Who knew a dog company suing a well-established alcohol company will end up in the Supreme Court? But it has. So, yes. All right. So, it looks like we got some members coming in from Uncivil Law. Says the viewers just joined. Say hello to anyone that is jumping in from Uncivil Law's live stream. I don't see anyone popping in quite yet, but if you guys are here, welcome in. Nice to see you. We are talking about the Jack Daniels lawsuit between Jack Daniels and a dog toy company. So welcome into the live stream. On your way in, make sure you go ahead and hit the like button to help us out with the algorithm. We are happy to have you here. So let's see. Okay, people are starting to pop in. It notified me a lot sooner than when everyone popped in. So yes, guys, welcome in. We are happy to have you. We are talking trademark and not summary judgment in the Supreme Court for the Jack Daniels case and the dog toy. So I just wanted to repeat that for the people that are just popping in. If you can, be sure to go ahead and hit the like button to help us out in the algorithm. And if you're not subscribed already, please do subscribe. We are on a road to 50K subscribers this year, and we would be happy if you joined us on the trip down to 50K subscribers. All right, let's go ahead and jump back into the lawsuit here. They sued Jack Daniels. They turned around and said, hey, you're not going to send us cease and desist letters. If you're going to send us cease and desist letters, we're going to go ahead and sue you to make you stop sending us cease and desist letters. All right. The district court denied VIP's motion and granted Jack Daniels' motion, so they lost. The court ruled as a matter of law that Jack Daniels established the first two elements of its infringement claim, the distinctiveness and non-functionality of its trademarks, and trade dress. The court further held that Jack Daniels raised triable issues of fact on the remaining infringement element, namely that VIP's use of Jack Daniels trademark and trade dress likely caused confusion. So not only did VIP sue Jack Daniels first, the court shut them down and basically was like, no, you guys are wrong. You guys are copying Jack Daniels. So let's see. I want to see what's going on in the chat here. We are at 51 likes, guys, and we have 78 people watching. So if you have not hit the like button, please do. We're trying to get to our goal of 100 likes per stream. So hopefully we can get there today. Let's see what's going on in the chat here. All right, we got C Ty. Welcome in. I guess coming from chats from Kurt's live stream. Welcome in, saying that's better. Let's go in. Star Bright says, hey there from Uncivil. Well, hello, welcome in, welcome in. Asher Mama says, hello, Uncivil crew. Yes, everybody, welcome them in. DL says, squeak, squeak. Hello. Elizabeth Carmichael says, hey, Uncivilians. Hello, welcome in. Madema, I don't know if I'm gonna say this right. Madima Rose says, I'm gonna sub, but I gotta jet another time. Well, thank you. Welcome in. Thank you for stopping by. Off-Rail Rusher Gator says Seattle drivers got very ugly in the rain. Strangely, not aggressive, just silly ugly. Huh. As far as driving in the rain. Nick M says, my question, has this hurt Jack's sales? I have not read that yet. Possibly, maybe not. I guess we can see. It doesn't necessarily have to hurt their sales, but it's just the potential of hurting their sales, and that's what they're arguing. Tiny D says, all good to Deacon Fatal. I'm about to be on listen only and work on this shirt. Yes, get the shirt done. Hello, Swaggy says, welcome to the Bree High, folks. Don't forget to finesse the algorithm. Please hit like. Yes, thank you so much for that. Off-Rail Russia Gator says, LA drivers are very sophisticated / polite, very easy place to drive as large American cities go, in my honest opinion. If you are not a member, Hello Swanky reminding us how to join the membership, get some cool badges, cool emojis, and support the channel. Can't read that name, saying, regarding the mac and cheese case, isn't there a disclaimer about microwave times may vary depending on the power? On this particular picture of the box, I did not see that on there. Usually there is something that say that. And we did mention it earlier in the stream, but maybe it is there. Oh, let's see. Let me show you guys here. It says, warning, help prevent risk of fire, add water to the line, do not leave microwave unattended. This one, it does not. Yeah, this one, it does not. It may be on a different side of the box, but on the picture that they presented, it does not tell them that microwave times vary. So maybe they'll get that fixed soon. C-Ty says, uncivilian trying to be civil for Bree. That is okay. Well, welcome in to Hey Uncivilian, says Carrie Todd. Welcome in. Cheryl C says, my hot take, I'm usually firmly on the side of satire, but this one seems like unquestionable trademark infringement, but they are claiming satire to get past it in court. And the thing is, they have been sued by other companies. What company did they say just sued them? I think it was I think it was Budweiser that recently sued them before this. And basically they tried to get ahead of it by going to court and showing, hey, no, we're not infringing. Hey, judge, please tell them we're not really infringing. This is the same thing that Selena Gomez did. I can't remember if she filed first, but they basically asked for a declaratory judgment for the court to tell them, like, hey, no, this is not infringement. I own the trademark. In this instance, they're like, I have a First Amendment right to basically create things. Even if it infringes on your trademark, I'm not trying to sell alcohol, so you should know that I'm not infringing. But as Jack Daniels already said, they also sell dog toys. So yes, it is also infringing, and they could have licensed it from them and also had the creative direction of which way they could go. They don't want it related to number 2 versus number 7, all of the things that they did. Let's see. I think it's Sousa. I'm going to go with Sousa. I'm saying cases like these are why Americans are not respected and seen as jokes in the rest of the world. Hey, and they're going to keep coming for us. They're going to keep coming into the lawsuits because people sue. People really sue about everything. I did not realize that they did until I went to law school, and now I know people will literally sue about anything. Hello Swanky says, Deacon Fatal, I can't do anything. I wasn't the one who timed them out, but I think they're fine in front of Uncivil Laws channel. Oh, okay. I guess there's some moderating going on in there. I don't know exactly what happened. Destinade says, Budweiser for the butt wiper. Yeah, that's what they called it for Budweiser. Yeah. I would stop that too, right? You don't want your drink called that. Tiny D says, they're fine. Hello Swanky. They popped in first and seemed random. That was me. Sorry. Oh, okay. You guys fix it. Moderating. Okay. Let's get back into the case here. This is our Supreme Court petition for basically to get rid of this trademark infringement. And if they have First Amendment rights, I don't think that they should, but we'll see what the Supreme Court says. Let's see. The district court rejected VIP's defense that its dog toy merited heightened First Amendment protection under the Second Circuit's framework in Rogers versus Grimaldi. Actress Ginger Rogers claimed that use of Ginger and Fred as a movie title violated the Lanham Act by creating a false impression that she had sponsored the movie, concluding that the expressive element of titles requires more protection than the labeling of ordinary commercial products. The Second Circuit construed the Lanham Act to avoid intruding on First Amendment values applicable to titles. The court held that in the context of artistic titles, infringement will not lie unless the title has no artistic relevance to the underlying work whatsoever. If it has some artistic relevance, unless the title explicitly misleads as to the source or the content of the work. I don't know if that one really goes for them because titles, you can't get trademark for titles. So it sounds like this Rogers person had a trademark. I'm not all the way familiar with that case, but Rogers had their own trademark and someone named a movie title after it. But movie titles are not normally protectable under trademark law unless it's a series of movies like the Harry Potter saga or something like that. So I would have to look at that case a little bit more to see if it applies, but it almost feels like it doesn't apply in this situation. The district court here dismissed Rogers as limited to use of trademarks and titles or expressive or artistic works such as movies, plays, books, and songs. By contrast, VIP infringed Jack Daniel's trademark and trade dress to promote sales of a commercial product. Okay, yep, that's where I was going. The court reasoned that trademark law regulates misleading commercial speech where another's trademark is used for a source identification, and the First Amendment does not extend to such use. Accordingly, the court held that the Lanham Act standard likelihood of confusion analysis is governed by Jack Daniel's claims. With respect to dilution by tarnishment, the district court rejected VIP's parody fair use defense, which is all it is a defense. It does not necessarily mean that they're not infringing. Let's see. The court observed the 15 U.S.C. 1125 C3A excludes from dilution liability any fair use other than a designation of source for the person's own goods or services including use in connection with parodying, because VIP use of Jack Daniel's trademark and trade dress as a source of designation. The court concluded that the parody exclusion did not apply. The district court further held that Jack Daniel's raised triable issues of fact concerning its dilution by tarnishment claim. The case proceeded to trial on those claims as well as the remaining likelihood of confusion element of the infringement claims. Following the 4-day bench trial, the district court ruled in Jack Daniel's favor on both the infringement and dilution by tarnishment claim. With respect to infringement, the district court found that bad spaniels was likely to cause confusion. In particular, the court credited the opinion of Jack Daniel's survey expert that approximately 29% of potential purchasers believe bad spaniels was associated with Jack Daniel's. The court added that 29% was nearly double the 15% threshold courts typically recognize in establishing confusion. So they did a survey, which is a good tactic to use in infringement cases, because when you're trying an infringement case, you do not necessarily have to show actual confusion. But if you can show actual confusion, that makes your case a lot stronger than it would be if no one was actually confused, right? Let's see. Off-Rail Rusher Gator says gender was like a Jay-Z of her day, not a subtle branding or particularly blurry back then, one might guess. Hello Swanky says to Off-Road Russia Gators, welcome to the Bree Hive. Apologies for the mix-up. Glad you're here. Also agree with your comment about Teslas. They need to get that together ASAP. Susan says, kind of arrogant for that mac and cheese lawsuit to think that think they're that important, valuable, that their time wasted in damages is worth even 1 cent. We're 7 billion people here, not Special McMuffin. Well, that's the thing. I'm wondering for the Velveeta case, how are they going to value that extra 3 minutes that they felt like they lost, right? And what kind of tests are going to be run? How long did it take to actually heat it up? How long did it take for the cheese to thicken? Questions that need answers. Off-Road Rusher Gator says, hello, Swanky. Thank you. Seems friendly place. Host tonality is way cool for folks not into the whole law profession thing. Probably bring many civilians into engagement intellectually with law. Yes, that is true. We have a cool little chill place over here. I know there's a lot of other lawyers on YouTube that has a chill little chat as well. Let's see. Off-Rail Russia Gator says Twitter is a term long unicorns. At this point, it's term on Elon's takeover. LOL, almost hard to just comment. Oh, am I not supposed to say that on YouTube? Twitter? Oh, well. It's too late. All right. Let's see what's going on here. In the case a little further, the district court further found that Jack Daniel's trademark and trade dress were extremely strong. I would agree with that. Intended to produce a dog toy that included and was similar to Jack Daniel's trademark and trade dress. Let's see, that VIP sought to capitalize on Jack Daniel's popularity and goodwill for its own gain. I would agree with that. The court also found that Bad Spaniels and Jack Daniel's licensed pet products were related goods sold in the same class of purchasers and through some of the same stores. For these reasons, the court found that Jack Daniel's had proved likelihood of confusion and thus prevailed on infringement claims, which I would agree with, especially since they are already licensing their name to other dog toy manufacturers. I think they have an even stronger case than if they were not also already selling toys. It would be harder to say, oh, I'm an alcohol company, but I intend to start selling dog toys, so they are in the same channels of trade as me, versus I own this trademark and I have also licensed this trademark to dog toy manufacturers that actually sell in the same stores that this person is selling in. So they are infringing and they are in the same channels of trade as me because I have licensed it into that channel of trade. Let's see. The district court also concluded that Jack Daniel's proved dilution by tarnishment. Specifically, the court found that Jack Daniel's trademark and trade dress were famous. VIP intentionally appropriated them in every aspect, and the Bad Spaniels likely tarnished the reputation of Jack Daniel's mark by, among other things, creating negative associations between the product for human consumption and dog poop by associating marks with toys that might appeal to children. I didn't think about that. Dog toys, I guess, could appeal to children. That is true. I did not think about that, though. All right, guys, we are at 60 likes, but we have 57 people watching live. So if you have not hit the like button, please do help us reach our goal of 100 likes per stream. Let's get there. All right, let's see. The district court permanently enjoined VIP from manufacturing, advertising, or selling Bad Spaniels. Jack Daniel's did not request damages. If I was Bad Spaniels, I would just give up because you're spending all of this money on attorney's fees hoping to win it back. And Jack Daniels did not even ask for damages. They just wanted them to stop. This is actually better than a lot of big companies that sue because usually they ask them for attorney's fees and they also ask them for money damages, their profit, all of the things. They don't even want to be associated with them. They literally just want them to stop. The Ninth Circuit affirmed in part, reversed in part, vacated in part, and remanded. The Ninth Circuit did not disturb the district court factual finding that VIP's use of Jack Daniels' trademark and trade dress created a likelihood of confusion. Nevertheless, the Court of Appeals vacated the judgment on infringement claims on the ground that Bad Spaniels merited heightened First Amendment protection. I don't like that, appeals court, but let's see what else you guys have to say. The Ninth Circuit did not address the district court's ruling that the First Amendment does not protect misleading use of trademarks as designation source. Instead, while acknowledging that VIP's dog toy was surely not the equivalent to the Mona Lisa, the Court of Appeals held that it was an impressive work because it communicated a humorous message. The Ninth Circuit thus applied the Second Circuit's framework of Rogers. So, appeals court somewhat agrees with VIP. As interpreted by the Ninth Circuit, the framework requires a Lanham Act plaintiff to prove not only likelihood of confusion, but also that the defendant's use of the mark either is not artistically relevant to the underlying work or explicitly misleads consumers as to the source of the content of the work. The Ninth Circuit vacated the judgment and remanded for the district court to determine whether Jack Daniels could prove one of the two Rogers prongs. With respect to dilution by tarnishment, the Ninth Circuit reversed. The Ninth Circuit did not question or even acknowledge the district court's holding that the parody exclusion in section 1125C3A did not apply because VIP used the trademarks and trade dress to designate the source of the product. Instead, the Ninth Circuit invoked the separate exclusion in section 1125C3C for non-commercial use of the mark. I would say it is commercial though, because they're selling them. The court explained that even though VIP used Jack Daniels' trade dress and bottle design to sell Bad Spaniels, VIP was nonetheless non-commercial because it conveyed a humorous message. What? You think that's non-commercial because the message is humorous? It is commercial. They're selling it. And they want people to buy it because it mimics Jack Daniels. Okay, whatever. Let's go on. The Ninth Circuit thus concluded that such use was protected by First Amendment and that VIP was entitled to judgment on the dilutions claim. The Ninth Circuit denied panel rehearing and rehearing in Jack Daniels' petition for a writ of certiorari, I can't say that word, miscite representing mark holders in diverse industries filed 6 amicus briefs urging the court's review. VIP urged the court to deny certiorari in part because the case stood in interlocutory posture. The court denied the petition. Let's see, on remand, the district court granted the summary judgment. It went on and it went on, and let's see. Okay. Sorry. I was almost done, but I got tired of reading. So let's see. We got one more page here. Let me actually check out some of what the chat is saying. Elizabeth said, you should look at the mischief amicus brief for this. It's amazing. They're going forward on Supreme Court as well. Is that on the same is that on the Nike lawsuit case for them? Cheryl, they get sued all the time. So I'm like, which case is it? Cheryl C says, Jack Daniels just wants to protect their brand. They don't want damages. VIP is spending so much on fighting this. It makes no sense to me. In my opinion, they don't really care about the First Amendment principles. They basically want to be able to continue to do this. It's not just about Jack Daniels for them. It's about their whole business model. They want to be able to continue to create parody dog toys without actually needing to license the right to use the trademark or the trade dress from these companies because it makes their profit margin higher. I don't think that they can make that much money off of these dog toys, but maybe they can. But it's literally not just about Jack Daniels. If they win against Jack Daniels, then they also win against the other companies that they are trying to play off of. Hello, Swanky reminded us to become a member of the Bree Hive. Yes, yes, thank you so much. If you guys are not members and you're interested in being a member, you can hit the join button, get cool badges, cool emojis, and support the channel. Nick M says, Boss Attorney Bree, let's put both in liquor section of the supermarket and let people decide. I think if people wouldn't be confused, let me say this. I don't think people would be confused and buy the toy thinking that it's actual alcohol. I think people will be confused and buy the toy thinking that it's something that Jack Daniels made to go along. Just like when you go into the store and some of the Jack Daniels is sold with like a bottle in the cup. And you think, oh, it's a package, it goes together, it's cute, it's novelty. In this situation, be like, oh, I'm getting me a bottle. Let me get a toy for my dog, because Jack Daniels also actually sells toys. Now, if you put the dog toys, I think if you put the two dog toys together, the one that they license and the one that is not licensing but using its goodwill next to each other, I don't think people would be able to tell which one was actually licensed and which one was not. I think people would just assume that they both were by Jack Daniels, to tell you the truth. Let's see. Off the Rail says, haven't done the study or anything, but intuition is dog toys could definitely appeal to some kids depending. Yes, I've seen kids play with dog toys. I definitely seen kids play with dog toys. They're probably not supposed to, but they do, even if it's after the dog has chewed on it. Or maybe for whatever reason, you're, parent of the year and you take your kid to the liquor aisle and there's a dog toy next to the liquor bottle, and then so you buy one for you, one for your kid. Kid gets the toy, mom gets the real bottle. I don't know. Victor Man 777 late connect the dots in Amicus. Yeah, I think someone I think they dropped the link, but I probably missed it by now. Robert Heinz says, gotta get to bed. I'll get the rest on replay. Good night, all. Good night. Thank you for joining us live tonight. Elizabeth Carmichael says, no, it's on this case, Bree. Mischief sent the Supreme Court artwork and they're funny. Oh, yes, I think that's what someone was talking about, but I think I missed the link for it already. Off Rail, I haven't seen it. Off Rail, Gator says, a joke is forming about Jude Law and JD Bottle, which induces Okie better not. Okay. Deacon Fiddle says, it sounds like a horrible biz model. Yeah, just to copy famous brands and sell kind of like knockoff toys. Deacon Fiddle says, I haven't seen these toys. I haven't seen them either. I'm assuming they're more in pet stores. If you don't have a pet, you probably won't see them. Cheryl agrees with Elizabeth Carmichael. The amicus brief was incredibly clever, but I still think they know it is trademark infringement and are capitalizing on the current legal relevance of satire. Yes, I would agree with that. Off Rails Russia Gator says, this accidentally brought to mind an accidental friend who was at the time a VP for one of the big distillers. Gosh. Deacon Fado says, is this like Duff Bear? That is what it's sounding like. I'm not familiar with that one all the way. Hello, Swanky tapping out for a minute. We'll be back. Elizabeth Carmichael says they may be capitalizing, but as Bree said, they keep getting sued, so it does make sense. Yeah, and they're wanting to be able to get away with it, and so that's probably why they did the declaratory relief. Why go against Jack Daniels, one of the stronger trademarks? Don't know, but I guess if they can win against them, then they win against everybody. Let's see. All right. On remand, the district court granted summary judgment to VIP on Jack Daniels' infringement claim, holding that Jack Daniels did not satisfy Rogers. As to the first Rogers prong, the court observed that only the use of a trademark with no artistic relevance to the underlying work whatsoever does not merit First Amendment protection. Applying that test, the court found that VIP's use of Jack Daniel's trade dress was relevant to VIP's joke about dogs defecating on carpet. Really? Regarding the second prong, the court explained that the use must be explicitly misleading. So since they're not selling liquor, that's not misleading. Okay. Applying that high bar, the court found Bad Spaniels was not explicitly misleading because it altered Jack Daniel's trade dress, described itself as a silly squeaker, and had a minuscule disclaimer on the back. It's minuscule. You said it yourself. Oh, they're calling it minuscule. Jack Daniels is calling it minuscule. The district court thus reluctantly concluded that Bad Spaniels was entitled to First Amendment protection. However, it limited that it appears nearly impossible for any trademark holders to prevail under the Rogers test. Yes, the Rogers test obviously needs to be changed because that's gonna make a bad space for a lot of trademark owners. You just say, "Oh, I'm making a joke, I can use it." No. Where relevance need to be merely above zero, the court explained it is difficult to imagine that what Creative Junior use would not pass the Rogers test. Similarly, the court continued the explicitly misleading standard essentially displaces the likelihood of confusion test with a standard that excuses nearly any use less than slapping another's trademark on your own word and calling it your own. Consequently, the court bemoaned Jack Daniels and similar mark owners have no means to protect their viability of their mark in the Ninth Circuit and must seek relief before the United States Supreme Court or the United States Congress. I agree. Thank you, Ninth Circuit District Court, for saying that. It would make it very hard to protect your trademark. You just got to call it a joke. You just got to call it a joke. Okay. Jack Daniels appealed on Jack Daniels' motion. The Ninth Circuit summarily affirmed the judgment based on the prior panel's ruling. Subsequently, the court denied rehearing en banc. Let's see. Reasons for granting the petition. Number one, I'm going to just kind of speed through these ones. Number one, the Court of Appeals are divided on the question presented. The Ninth Circuit embraced the First Amendment protection for humorous trademark use, conflicts with decisions of the Second, Seventh, and Eighth Circuits. Let's see. We're not going to go through all of that. They explain a lot, and my voice is tired, so we're not reading that today. Secondly, the decision below creates a conflict by dilution by tarnishment liability for humorous use of another's trademark. I'll probably read this off screen, but not today. Let's see where we're at. We got some pictures. Let's see what the pictures are talking about. Okay. Next, the question presented are recurring, important, and squarely presented. We know they're recurring because VIP is using everybody's. They're using everybody's, and this is coming up in other cases as well. Let's see. We have, not the double slit stone out. Oh, yeah, there are the cases with like the weed candy. So yeah. This is coming up a lot. I didn't even think about these cases. And then what does that one say? Recently sued its trademark against infringers selling bearing Patagonia's mark. Oh, wow. You guys can read that. It says, Patago F yourself, a-hole, live forever. Basically playing off of the Patagonia. I don't know exactly what Patagonia is. But yeah, they're just playing off of a bunch of things. And they're like offensive to the people that have developed these brands. I think that's all for this petition that I'm going to look at. But they are supposed to be hearing this case on Wednesday. I don't know exactly how long it takes for the Supreme Court to come out with a decision, but I will be keeping an eye on it to see what happens because I didn't even think about all those THC cases and things like that have been coming up. So this would be a good case to go in front of the Supreme Court and actually get a decision on it. Like, is this infringement? Is it not infringement? I would say it is infringement. Otherwise, you're going to be opening the door for people to basically just use whatever trademark they want and say it's a play on words, say it's a joke, whatever you might want to call it, just like we just saw the Oreos. I don't think it's right. I think that they should be leaning more towards trademark infringement for this so that it does not continue to happen and so that brands can actually protect their trademarks. All right, guys, if you haven't already, please do hit the like button. If you're not subscribed already, please do hit the subscribe button. Help us out in getting to 50K subscribers this year. Off the rail, Russia Gator says Amber got some branding opportunity left. Johnny may be from tobacco country, but Kentucky's also known for some alcohol. Nice to know. Elizabeth Carmichael says, Bree, if you want to connect the dots, get in touch with Emily D. Baker. She can send it to you. I will check it out. I feel like it sounds familiar, but it's just not popping into my brain right now. Off the rail, Russia's Gator says, won't Elon go after that most personal mobility challenge? Squeaky wheels get heard. DK Fatal says, I do have to head out because work and I need to start working on this score. Well, thank you for joining us live. We are almost tapping out of here anyways, but if you gotta go, you gotta go. Thank you for joining us and thank you for the super chat. DQ Fatal says, very nice to meet you all. Yes, of course, to all the uncivilians popping into the Bree Hive, causing some conversation. Thank you for joining. Off-rail Russia Gator says, for the plaid, they had to solve encapsulation problems to a motor which apparently spins faster than anything like that on Earth had until that point. Motors, batteries come on Elon chairs. Talk about the Teslas. Hello, Sunky saying goodnight to Deacon Fatal. Off the rail says score, work, sound, LA. I don't know exactly what you're referring to there. And then Nick M says it will probably at the end of the term. And then Tiny D says tomorrow, Wednesday, or next week. I think tomorrow, Wednesday. They're supposed to be hearing this on tomorrow, Wednesday. But I will double check and make sure. And then I'll keep an eye on whenever the opinion comes out because I do want to see what the outcome is going to be on this case. It seems like a very slippery slope if they allow this to not be trademark infringement. I don't know what you guys think about it, but I think it's a slippery slope. If you guys have not already, please do hit the like button. We're not quite at our 100 likes for the live stream, but that's okay. We still had a great time. We will be back on Thursday at 6:30 Pacific Standard Time, covering a case that I don't know what it will be yet. There's some stuff coming out about the Idaho murders that I think I want to jump on, but I just haven't had time to really sit down and look at everything that has been coming out. So we may be going down that road on Thursday. Unless something else comes up, we might go down a different road. Thank you guys all for joining me. Thank you for the uncivilians for hanging out with me as long as you have. If you have not already and you would like to hang out with us on more Tuesday and Thursday evenings and even on some weekends when we do our member streams, please do hit the subscribe button, hit the like button, turn on notifications so you know when I am live if YouTube decides to notify you. Thank you to all of my subscribers and my members and my OG Bree Hive supporters that have been here watching me. I will see you all on Thursday, and I hope that you guys have a wonderful, wonderful night. Thank you for joining me tonight.